Good afternoon, everybody, and welcome to the monthly Real Property Law Section webinar where we tell you or we talk about some current events in real estate law. I'm Neil Kalin. You can see Michael Simkin is right there. Nice little headshot there, Michael. And we have a guest that we're interviewing today, Jeff Huron. Hi, Jeff. Nice to see you. Welcome.
Good afternoon. Thank you for inviting me. I'm glad to be here.
Wonderful. We're glad to have you, and feel free to, speak up on any of the cases that we're discussing if you have, something of value to add, which I'm sure that you do. So welcome, everybody. Again, let me get us started here, see what our agenda is going to be for the day.
Neil, by the way, today's a special day in history. Did you know that?
I did not know that. What's the day?
It's the Ides of March.
Ides of March.
A very auspicious day if you were a Roman emperor.
You know what? And as soon as you said that, it struck a chord with me, because that is the date of my father's birthday, the Ides of March. Yes.
Oh,
So,
that's great.
so far from us having any kind of emperor genes in the Kalin family, though. So what are we going to talk about? Just real quick, we're going to have we're just barely a week away from the Real Property Retreat, which is held in Sonoma this year. So we'll have a slide on that. Then we're going to talk about two cases. One of the cases having to do, these cases keep coming up, having to do with COVID and whether there's an excuse from rent and whether there's insurance, and a lot of stuff still going on in that arena. Then we're going to talk about the Degala case, and not the famous talk show host Jon Stewart, but a general contractor, Jon Stewart here, and just what to do, or whether an employee we see here of a subcontractor can sue the general, when there's been an injury on site. We've got our interview with Jeff, which we're very excited about. And then we have a appellate division of an Orange County Superior Court case, Attinello versus Basilius, which has to do with a landlord and a tenant entered into an agreement where the tenant agreed to give up possession and the tenant did not, but the court was not buying the agreement, and we'll talk about that. And we end up talking with SoCal Recovery about a sober living home. And the issue there was whether the living home could bring an ADA, a fair housing and unfair employment and housing claim when they were denied permission to continue their use after a change in ordinance at the local level. So those are our topics for today. So the first one is, if you haven't signed up yet to go to the Real Property Retreat, it's going to be another great event this year, a day of meetings, networking opportunities, some fun opportunities. You see there's wine tasting, there's dinner and dancing. There's it's done in association with Women in Commercial Leasing Law, I believe is the name of the group. If you like me, I'm actually going to be speaking twice during two separate concurrent sessions. One, I'm giving a year-long case update with one of my colleagues, Elizabeth Blair, and then with some other colleagues, I'm going to be talking about real estate market client strategies, legal strategies, not real estate strategies. So you see the agenda there. Still time if you want to come up, and we hope you join us. So let's start. We'll talk about the first case, the SVAP 3OA versus Fitness International. And what do I have here? An interesting case because it took a really different take on a lot of these COVID cases that we've been seeing. And so here, SVAP owns a shopping center. Fitness, owns a gym or a fitness center, or operates a fitness center within the shopping center. the lease goes through October of 2025. Obviously, in March 2020, there were the shutdown orders, the stay-at-home orders by the state of California, and of course many local entities as well. And fitness could not operate its gym or its fitness center because of the stay-at-home orders. Now, originally, evictions were prohibited, but that wound up stopping. But even though there were prohibitions on evictions, even for commercial entities, the eviction restriction did not relieve the parties of the obligation to pay rent. So what happened here, a couple months after these orders came into effect, fitness wasn't paying their rent, so SVAP sued for non-payment of rent, and this is really early on, right? Just April and May of 2020. Fitness answered, and SVAP filed a motion for summary judgment. By the time they got around to filing, there was 8 months rent that was being owed. What did the trial court do? The trial court granted the landlord's motion and awarded the landlord over $500,000, finding fitness was not excused from performance. And that's going to be kind of a real key to this case. The trial court said, well, fitness, your obligation was to pay rent in exchange for possession of the property. There was no promise in the lease on the part of the landlord that you would be allowed to continue your specific use as a fitness center or as a gym. Fitness wound up appealing to the appellate court. The appellate decision went through a number of issues. And I'm just going to kind of summarize, the bottom line holding is the appellate court agreed with the trial court and said, fitness, your obligation was to pay rent. There was nothing stopping you from paying rent, right? You could not operate your business, but there was nothing stopping you from paying rent. None of the stay-at-home orders stopped you from paying rent. That was your obligation. Fitness was raising a bunch of issues, breach of contract, force majeure. What I thought was really good about this case was the court distinguished between impossibility or impracticability and frustration of purpose. So, like I say, kind of an interesting case. Michael, what's your opinion about this case?
Okay, this case I found disturbing, okay, but the court just focused, like you said, on the ability to pay rent. The purpose of the lease was to pay rent to the landlord. This took it all one-sided over and over and over. The case was also filed very early on in the COVID time in May 2020, where all of the different cities and counties were trying to figure out where we stand and what's going on with COVID and rent. And as time progressed, we found that every 3 weeks or 3 months, there is some new laws. San Diego did pass some laws about evictions and prohibiting evictions. They also passed some laws about when rent would be due or deferring the payment of rent. And I have the links there. I'm going to post in the chat in a minute. But what I don't understand is why the tenant didn't bring that up, because by the time of the summary judgment motion, I think that San Diego already had in place this rent deferment concept. So I don't know what happened there. The force majeure is something that I remember looking into this a few years ago. Some force majeure clauses, not some, a lot of them, they just say the inability to pay rent is not a factor. And while we don't have the actual lease in the opinion, the language, that's what they said. So they kind of got screwed. I don't understand the impracticability and impossibility because of the court orders saying for at least several months, they couldn't operate the business, but they kept twisting it and saying, oh, the issue is, can you pay the rent? And at least you've been there for a long time. You've been there for years. And there is some phrase apparently in the lease about 1 day to operate, and the landlord did that. So I just found it disturbing. It's not fair. But I have also been observing other cases that have been coming down the pike. And judges are treating these cases very differently. So this is unique because this is one case, but I've seen some cases recently in Los Angeles where landlords are taking different arguments, such as, well, the purpose of all of these rent deferments is really for residential tenancies. So while it has a word commercial, it doesn't really mean that. Or I have one case talking about the landlord saying there's a prohibition on commercial rent control in the state of California. And these COVID rent deferment laws are basically that. It's not. But there are a lot of these cases, and they're going to be working their way through. This is just the first one that I'm aware of at the appellate level.
I have to tell you, I was actually a little bit impressed with the argument that the appellate court made about frustration of purpose, saying that that applies to the entire lease term, not just to this interim period of time where the tenant was unable to operate their fitness center. So I thought that was an interesting discussion that they had on that one particular issue. Michael, you said you found this case a little bit disturbing. I could certainly understand the argument, and then certainly I don't know procedurally why they would not have raised a local ordinance as one of their defenses. It says here they answered with 378 affirmative defenses. I don't know if I have that right. Maybe
I think that's a typo. I think it's 37.
I think that's a typo.
Yeah,
Yeah,
it's a
37,
typo.
38. But
Yeah,
it seemed to me that would be another one of a good one to add there. Yes, so no doubt that was a typo there. But you found this case disturbing. So do you think landlords just have to suck it up when tenants say there was an order and I couldn't use my space for the purpose that I intended to use it for?
You know, there's another avenue here, which is about if the landlord has, business interruption insurance. There's a lot going on. And also the rent, there are no jurisdictions in California that waive the rent. It's just a matter of deferring when the rent is paid. So I think that the landlord just has to wait. This is like a legitimate business or company that if they couldn't pay the rent then, if it's deferred 3 months or 6 months or 1 year, like currently, like in Los Angeles, the commercial rent is deferred for a year after the end of COVID. So it's basically they have till next spring to pay. So yeah, the landlord's not getting their income for that period, but I think they need to wait. COVID was a very unique and disastrous impact on people. And so I think there's a point. I think that this court is just wrong, but I don't know what happened with the local laws, why they didn't consider that.
And so you're not excusing the tenant entirely. You're just saying that if you were the judge, you would have thought that SVAP's claim was basically premature. And
I would say that
maybe would have been better later.
Yeah, the landlord is not delivering the service that the landlord is supposed to provide. The landlord is not in breach because of the government orders. But the tenant is also not in breach of the lease because it was prevented by the government from operating the lease. Plus, at some point soon thereafter, they had this rent deferments in place. And by the way, Neil, I wanted to find the chat. I don't know what I clicked on, but I don't see the chat because I wanted to put the link to the San Diego ordinance.
Okay, well, we'll let you figure that out. It's usually either at the top of your screen or at the bottom of your screen. And then maybe if you just hover, you could figure that out. We're going to move on to our next case, unless Jeff, you want to add something.
Yeah, I was just going to add a couple of thoughts here. One, first of all, I was kind of curious about the 378 affirmative defenses. I was wondering what the motion for summary judgment looked like. That must have been quite a tome. But anyway, when I guess it was maybe in 2021, we had 2 landlord clients that were owed a lot of money in rent. And so we did file breach of lease cases, one in San Francisco and one here in LA. And what we did in those cases rather than what was done here procedurally, which is, motion for summary judgment and an appeal, is we brought applications for right to attach orders in both of those cases for substantial sums of money, 7 figures in both of those cases. And both of the judges actually granted those applications for right to attach orders along the grounds that the Court of Appeal here decided. And the value of doing that is, in one case, we ended up renegotiating the lease. The landlord did with the tenant and got some rent money and gave them some more time. And in the other case, the tenant filed bankruptcy. So what that allowed the landlord to do was avoid all these legal expenses and delay by just cutting to the chase, by bringing the application for a right to attach order out of the box and see how the court viewed these issues. And in my experience, the courts have generally favored the landlords, finding that there hasn't been an impossibility or frustration of purpose or an impracticability for the same reasons the court did here, which is it didn't preclude the tenant from operating other types of businesses to stay open. And in the case of gyms too, one thing, certain gyms were allowed to remain open if they had their activities conducted outdoors and people were, 6 feet apart and things like that. But that would be another way, if you have any people, representing landlords, is to think about whether or not it makes more sense and it's more efficient to bring an application for a right to attach order.
Yeah, I agree. That's a good way to test it. I'm assuming you had similar force majeure clauses about the inability to pay rent is not an excuse.
Correct.
Yeah,
And I think most leases had that language that was generally favorable to the landlords in my experience. Other people may have different experience.
No, but that's great to hear, Jeff, because what you're saying is this case is probably not really an outlier case, and that it may be representing more of what's going on rather than the exception of what's going on.
I think that's right. And I would suspect in San Diego and Orange County, they're probably more pro landlord than even LA and San Francisco.
But
Okay,
if
great.
wait, Jeff, if you thought that there was the local ordinance that had the rent deferment involved, would that trump the force majeure clause?
That's another interesting question. I mean, I think it does have applicability, and I think that's what I would argue as a tenant, but I don't know how the courts would rule on that per se, especially if these were sophisticated parties and, they were running, sophisticated businesses, but the law is the law. They need to apply the law. And if the tenant is excused from paying the rent, then they're excused from paying the rent. But what happens many times, Michael, is that the rent hasn't been paid for either a period of time before the ordinance was enacted, or the rent still hasn't been paid after the enactment or the ordinance stopped protecting the tenant. So there's usually some amount of rent that's not protected by the ordinance. That's kind of what usually happens.
A lot of these ordinances say it went back to like February 2020 when the crisis, the emergency orders were first enacted. So that retroactivity could have helped them. I mean, most cities have that. But interesting case, but I agree with you. I'm just amazed the force majeure clauses. I've looked at a lot of them. There's a lot of commercial leases that don't have them, or they didn't have that language about not excusing the language to pay rent, which I thought would be the basic language I would want.
Well, what we try to bring you here and What's Up With Us is cases that are interesting, right? We don't want the boring standard run-of-the-mill cases. It looks like this one fits the bill pretty well. Let's see about our next one. See if that results in some kind of a discussion with the three of us. And here we have Tagala versus John Stewart and Company. And here's a case where you have some work being done on a couple of properties or adjacent properties. There's a walkway in between the properties, and there was real security concerns at these properties. So it sounds like it was in a dangerous area. And it was, I believe this was somewhere in the San Francisco area. Sounds like it was a dangerous area. There was shootings, there was murders. It was very problematic to be in that area. The owner, in conjunction with the general contractor, took various steps. They had cameras, they had fences around the property. At one point, they had a fence around the two properties together, including the walkway in between the two of them. But the neighbors complained that they were using that walk area to get to the bus stop. So the owner and the subcontractor and the contractor, excuse me, said, okay, then we will just fence off the individual properties, right, and leave the walkway. And of course, where did the employee of the sub get hurt? In that walkway in the area that wasn't fenced off, because the owner and the contractor decided to try to be accommodating to the neighbors, right, who wanted to make use of that area in between. So there was a number of steps. This kind of boils down to, you see there in the appellate decision, the case, the premier case is Privet versus Superior Court, that basically excuses the hirer from liability to injury sustained by the employee of an independent contractor. But an exception to that rule is if the hirer, who could be the owner or the general contractor, in some way retains control over the workspace, and negligence in retaining that control led to the injury. And so the appellate court here said, well, you know what, there's going to be a question of fact as to whether there was control and whether the activity engaged in by the owner and the general, like I say, it seemed to me they were in a no-win situation. Either they kept that fence around the two combined properties and got complaints from the neighbors, or they opened it up, just protected their own buildings that were being, remodeled or improved, and exposed the workers that maybe had to go from one property to the other. So there is going to be questions of fact as to whether the actions were reasonable or whether the actions led to the injury. Michael, what's your take on this one?
I agree from a common sense point of view. Who has control over it has to be responsible for the security. And also in this case about the issues, and the summary judgment motion was not appropriate. There's too many factual issues they had to consider. But from a practical point, if you're asserting some control over this walkway area, then you should be thinking about the security. The other thing I thought about, I remember there's a case that was called the Armand case, and it was about security and a landlord's responsibility for security. They have a responsibility to make sure the cameras are working, things like that. But unless the landlord, say, knows of prior danger, I mean, you can't guard against random attacks. If you know it's a very, dangerous area, there's a lot of crime going on, then that raises what you have to do. But there's a point, where, you can't control everything. But if you're going to be asserting control and do it right.
So do you think it's just a business issue? Like I say, at one point, according to the case, they had both properties, essentially roped off and protected, but in trying to be responsive to the neighborhood, they opened up that area in between, and lo and behold, that area in between is where the injury occurred. And is that just, kind of luck of the draw? You've got to balance, right, the potential legal liability versus your interest in the community and serving the community and trying to establish your reputation in the neighborhood where you're doing the work. And maybe you just try to balance that and hope that it works out.
Well, also that we don't know what sort of prior criminal activity was occurring there that they would have known about. I think that's where this case is going to hang on.
Yeah, well, I think it's pretty clear from the appellate decision that they were aware of criminal activity, which is why they installed the cameras. At one point, they say they told the workers, you cannot eat lunch outside. You have to stay in the confines of the building. So they were aware of what was going on in the neighborhood. Obviously, they weren't aware that
Yeah.
somebody specifically was going to be, injured. I don't know if they were shot or mugged. I couldn't tell from the case.
Well, they did have off-duty police officers as security, so they knew that, I guess, something was likely to happen.
Jeff, do you want to add anything?
The only thing I would add is, this is a perfect example of no good deed goes unpunished.
Yeah,
You try to make the place safe and you do the best you can, and unfortunately somebody gets hurt because of some third party and you end up being liable. Or potentially liable, depending on what actually happens at trial, I suppose.
so, but it's a good case for a reminder of what privet stands for and the exception to privet that you see there in the appellate decision paragraph, Hooker versus the Department of Transportation. So those of you who are involved in this kind of activity or have clients that are involved in this kind of activity, it would be good to refresh yourself with privet and the exceptions to privet as you are giving advice to your clients.
Yeah.
So now, guess what? We're going to turn it over to Michael. And Michael, you're going to lead our interview with Jeff. You brought Jeff in, and we're very appreciative because Jeff, I think, has a lot of interesting things to tell us about himself and his practice and what he does. So go ahead, Michael.
Thank you. So
Yeah, I don't know about all that though, Neil, but thank you.
Jeff is a very humble person, but he is one of the most intelligent and interesting guys I know. And
Thank you very much.
and he also likes to share some of his knowledge. Like we were speaking before about a case that he put in his newsletter. He has a very interesting newsletter called Sua Sponte. So Jeff, what made you want to publish a newsletter about your legal thoughts?
I guess I felt I didn't have enough to do. All joking aside, what really made me want to do that was, after doing this for more than 30 years, I figured that it might be worthwhile for me to start sharing some of the things that I do and the thoughts that I have about practicing law with other people, hoping that they might learn from my mistakes or see something of value and want to integrate that into their practice and way of practicing law. So it was kind of a way for me to try to give back to the profession and help other people.
Well, you're very humble because I know that you've had cases at all levels, not just during trials and appellate work and having a lot of practical advice for your clients. So do you have any practical advice for attorneys that might be watching as to how to maintain like a good balance between working, 60 hours a week and living your life?
Well, I do have some thoughts on it. I don't know if it's, a one size fits all, but I would say for the first 15 years or so of my practice, I was working pretty hard. And I don't know that I had a good work-life balance, but as I got older, I started realizing that it was important to do other things to keep fit, both mentally and physically. So I think it's important to take time away from work to do things that you really like, that make you happy. And when you find those things, you really should try to do more of them, and that'll keep you sane. Because as you know, practicing law, especially litigation, is very difficult, and you have to be on top of things all the time. So
You recently took a trip. Where did you go?
Well, I just took a trip of a lifetime. I've been wanting to do this for years and years and years. I went to Africa. I went to Dubai. Then I went to Tanzania, went on a safari, and then I stopped in Zanzibar for a few days and came back. And it was an incredible experience. And I'm glad that I did it when I did and didn't wait any longer, because long days, you're in a Jeep, there's no roads, it's dusty, it's hot, but definitely a phenomenal experience.
But how did you balance your responsibilities at work? Because you're also with the managing attorney in your office?
Yeah, I mean, that's one of the nice things about working, I suppose, in a big firm, is that you do have support and people can cover for you while you're gone. There were a few days where I didn't have any access to internet, but I was able to plan ahead and make clients and colleagues and opposing counsel aware of it. So I'm glad to report it went smoothly, even though I was gone almost 3 weeks. The longest vacation I've ever taken in my career.
And have you found it before that, when I first met you, you had your own office? What's the difference between having your own office and now working for a larger law firm?
In a nutshell, I would say the support, that you get in a bigger firm, and support in terms of, just staffing, but more importantly, the support from other lawyers who don't do the same type of work that you do, meaning laws become very specialized. And now, we have labor lawyers, we have tax lawyers, we have transactional attorneys, and, clients don't just need litigation, they need other types of services like handbooks and, advice about how to terminate employees correctly and things like that. So the nice thing about working at a bigger firm is that you have that support and you have the platform to offer all these other services that, smaller firms just don't normally do and can't provide. And the biggest thing about not having my own firm is, the lack of freedom and the lack of ability to, hire and fire people and have the kind of the technology systems that you enjoy working with that seem more user-friendly. You're not constricted to using basically what's good for the collective, if you will.
Even when you worked for yourself, you had a pretty decent sized law firm, but you found time to give back to the legal community as a member of the at that time one of the state bar sections. What did you do for that?
So I was on the financial institutions committee, or what was then the State Bar California, which has now become the California Lawyers Association. And I was on that committee for, I don't know, I want to say at least 6 years, maybe it was 8 years. And I ended up being the president for my last 2 years. And also I was on my alumni executive board for my school for about 8 years. And I ended up becoming a president of the alumni board, and then I turned off recently. So it's kind of been my mission over the years to try to give back to the legal community. And I think we as lawyers, I think we should try to strive to do that wherever we can. And I compliment you and Neil on, devoting your time to the real property law section.
Well, that's our sentiments. And for anyone, watching this webinar, there are a lot of different positions on different, now that we call them executive committees, for, estates and litigation and real property and privacy. There's like every concept that exists. There's a committee that's involved with educational programs, reviewing some statutes and some different, like the State Bar comes up with rules for professional responsibility. We get to have some input into these things. And if anybody has any interest in not just getting relationships with other attorneys, but having a proactive way of helping the legal community, I would strongly, recommend joining an executive committee as a member. So we're glad you did that.
Yeah, well, thank you. And I would just add to that, by volunteering your time, I actually think you get something out of it as well. You feel like you're making a difference, and it contributes to your overall well-being and happiness. I think you should take joy in that.
And you learn about new cases.
And you learn about new cases, and you meet interesting people.
Yeah.
Hey, Jeff, I got a question for you, and then we're going to go to our last two cases. And the question for you is simply this. I've already been impressed with your insight to the two cases we've discussed. For listeners who are impressed, who would want to get your newsletter, sua sponte, how do they do that?
Pretty simple. You just go to jeffhuron.com and sign up, put in your email address and you'll get it. I do it about 10 times a year. It's not very often, so don't worry about getting a newsletter in your inbox every week or even every month.
Okay, so Jeff or Huron.com.
Yep, thank you.
All
Neil.
right, great. Thanks, Jeff. I hope you stay with us for our last 23 minutes here. And let's go on to this Atenello case.
Thank you.
And an interesting case, right? It's an appellate division case. So limited precedential value. Hard to get a real good answer as to what the precedential value is of an appellate division case. Might be precedential for the district, the Superior Court district in which the appellate decision was decided. But we report a lot of these cases, particularly coming out of LA or Orange County, because even if they're not precedential, they are influential throughout the state. And I think this case has the potential to be. It involves something that I'm very involved in, because the form agreement that was used in this case was a form agreement that was developed by the California Association of Realtors. I work for the California Association of Realtors, and I help develop all of the forms that CAR puts out in the field. That form is no longer available, having nothing to do with this case. We stopped it because it only had to do with COVID period rent, and if a landlord and a tenant essentially agreed for a possession in lieu of back payments of the rent. That's what that form was. It was an agreement between a landlord and a tenant, where the tenant would give up possession at a particular point in time, and the landlord was forgiving the unpaid COVID period rent. So that's what that form was. When the laws changed, we stopped producing that form, and lo and behold, several months later, comes out with this case. And the appellate division, well, there was this agreement. Of course, the tenant, what brought this case forward is the tenant did not move out, as was stated in the agreement. The landlord, then proceeded immediately to an unlawful detainer. The tenant demurred and said, wait a minute, the form itself does not comply with the Tenant Protection Act of 2019. There has to be just cause, and you've got to give certain notices if you want to get rid of an existing tenant. Now, one of the reasons under the Tenant Protection Act is if there is an agreement to surrender possession. And the court basically did not buy that the form that was in use was sufficient to satisfy that requirement. Personally, I think, you've looked out at the appellate decision section on your screen, and I think the court really was stretching things with the first two arguments, saying, well, it wasn't the tenant providing the notice because the landlord gave this form to the tenant for the tenant to sign. But it was an agreement. And there are cases that say a surrender of possession, an agreement equals a surrender of possession. So whether it was initiated by the landlord or initiated by the tenant, I don't really see why that matters. The court made a big deal about that in this case. No, the tenant did not initiate that. Therefore, it's not a notice from the tenant to give up possession. Again, I think that, maybe none of the parties raise some of those cases that say an agreement is a surrender of possession. Don't know what happened, at the trial level.
But Neil, I'll give you my 2 cents.
Yeah.
Okay, so the first thing is, I'm curious, did Carr file an amicus curiae brief?
No, we knew nothing about this case until after it was published.
Okay, so what Carr did was a combination document. And the problem, I think, is it was an addendum to the rental agreement. It wasn't a notice, it was an addendum to the rental agreement. And this combination is what I think was the essence of the problem, because you have 2 statutes in play about how do you terminate a tenancy. And this addendum to the rental agreement failed both of those, okay? Even if the only thing I had a problem with this case where I would support Carr is if you had a lease that expired on its own terms, then you could file an eviction after that expiration date, right? Is that what you guys are thinking about?
No, that is not what we were thinking about. We were thinking that it is within the ability of two parties to a contract to agree to terminate upon their own terms. And
So
there's
you thought it was
consideration-
cash for keys? You thought this is basically cash for keys agreement?
That's essentially what this agreement was. We happen to have a separate cash for keys agreement, but essentially this agreement was in effect, it was a cash for keys agreement, but related to COVID period rent.
Yeah, so I think if it was more cash for keys, that's more of a notice, like we're going to waive this money and the tenant agrees to terminate on this date. I think that would have worked, but I think this addendum revising the rental agreement to make some changes was the problem. I think that was the beginning of the problem.
Well, you certainly agree with the court. What I'm saying is that's really taking form over substance. That's exactly what the parties did. They said, tell you what, the landlord's saying in the body of that form, the landlord agrees to forgive the unpaid rent if the tenant agrees to give up possession on a certain date. You know, so I don't care if you call it a notice or not. It's a mutual agreement to terminate the tenancy, provided certain conditions are met.
Yeah, to terminate in the future, as opposed to here's an irrevocable notice to terminate the tenancy. See the difference?
I would just add,
Go
so
ahead, Jeff.
so my thought is like, if you, and again, I haven't read the case, I'm just looking at your summary here. If you take this one, the separate act required, where the agreement says the landlord may file a UD after complying with CC section 1946.2. What if the agreement said instead that if tenant does not vacate on or before the date, that this agreement is intended to comply with CC 1946.2?
And that last item that you're mentioning now, Jeff, the last item about a separate act being required, that's part of the opinion that I could say, I don't have an issue, and I don't think CAR has an issue with that either, which is it was certainly open enough to say to a landlord, the agreement itself may not be sufficient. That I think the court had a good basis for saying that some separate act was required, and the landlord decided not to take that separate act, but to go straight from the agreement to the unlawful detainer. It's really with the first two segments of the opinion that I think are really stretched and I think ignore the reality of the situation.
So I have a question for Jeff, because I looked at sua sponte briefly today. There's a case about waiver. Do you think that the landlord who signed this termination addendum to his lease agreement has permanently waived the rent that was due, now that the court is saying that there's a defect as to the eviction aspect under this addendum?
I don't think they've waived the right to the rent. I think they just have to start over, right, and comply with 1946.2. I mean, if there's a fee provision, I guess they would be liable for the fees and costs of this action that was dismissed. But I think
I would agree with you, Jeff.
Yeah, I think if you say they can't collect the rent, then it seems more like a forfeiture to me or something like that.
And the on the second issue there, the issue dealing with service, the reason I've got a problem with that is you've got to look at what's the purpose of service, to make sure somebody is actually aware. And when both landlord and tenant sign something, I don't know how one could argue that the parties are not actually aware of the document and that they have not received the document that they've signed. But I agree with you, Jeff. I don't think there's a a waiver, it's just simply a matter of timing, right? That there was an extra step that the landlord should have taken in order to proceed with the eviction. Now, even if that extra step was taken for the appellate division here, that might not have even been enough for the appellate division. Okay, well, that's enough for this. Let's move on to our next and final case. SoCal Recovery versus the City of Costa Mesa. And here we have a situation where SoCal Recovery owns sober living homes, so group homes of 6 or fewer people who are recovering from drug or alcohol addiction, right? So it's people who have already gone through some kind of transitional housing. The city passed these laws in sequentially 2014 and 2015, requiring special operations permits. Sober Living already had properties in place. These properties violated these new sets of rules, requiring that there be no more than one property within 650 feet, or 2 properties cannot be within 650 feet of each other. SoCal requested an accommodation to take into consideration that they already have these places in existence, and was denied all along the process, right? Denied at zoning, denied at planning, denied by the city council, denied all the way. So, what did SoCal do? SoCal sued. SoCal said, well, these rules are in violation, or there's discrimination against us as an operator of sober living facilities, and that the prohibition of working against us is a violation of federal and state anti-discrimination laws. And so what do you see here? The city did a motion for summary judgment saying, no, you have to establish individuals with disabilities. You don't have the right as an operator to bring these claims. And well, SoCal appealed, and what did the appellate court said? Well, SoCal has standing on its own. It's an aggrieved person because it's being denied the ability to operate. And how can it establish that? It can establish that through testimony. They don't have to bring in proof of every individual living in the home has suffered from a disability. And what I really like actually is this last argument, regarded as disabled. So certainly under California law, you're disabled if you're regarded as disabled. And of course, the city says, we don't want these properties. We certainly don't want 2 properties in close proximity to one another because of our fear of who is living in the property. So it seems to me the city basically had an admission that they are considering the residents who are living in the sober living facilities to be covered or to be considered disabled under the state and federal act. So the trial court decision was reversed, but it was remanded. Do either of you have any thoughts on this?
I'm impressed by the court, how they summarized exactly what needs to be proven or shown in its conclusion of this case to meet its burden. Sometimes courts don't give the detail of the instruction what's needed. So for this reverse and remand, it's very helpful for that sober living facility.
Jeff, you took yourself off mute. You want to add anything?
No, it seems pretty straightforward. Yeah.
And the considered disabled, I like that phrase. That's an interesting phrase about the subjective belief.
Okay, and you know what? I just see that somebody, Jeff, do you have the ability to go into the chat? You're able to see how to do that? Somebody asked in the Q&A to post the directions for your how to access your sua sponte newsletter. So which is different from what was on the screen. What the screen was just your general email address at Dykema. And I'm
Right.
sorry if I'm pronouncing Dykema incorrectly.
No, that's
But
correct.
that was different for how to get your newsletter.
I think we're all set. Thank you.
Great. Wonderful. Okay. So those are our cases for today. What do we have? What do we have next here? We always want to tell people about what they could do, especially those real property section members. If you have a trust account, probably want to go to that March 29th or make sure you attend. I think it's virtual, that March 29th event on the CTAP rules and regulations. Those who practice in the real estate brokerage industry, kind of, or whether you do or not, there's a lot of lawyers who have a real estate license and think they could do certain things that they probably cannot do. So April 20th, risk to lawyers acting as real estate brokers. So I think that one ought to be interesting. And then just saw one come up, legal malpractice against real estate lawyers. So all of our real property section members who are listening, I think the May 24th one is something that would certainly you would be interested in. If anybody has an idea, any of you who are listening today has an idea as to something that you would like to see the real property section put a webinar on, or if you would like to put on a webinar on behalf of the real property section, there's the contact there, Marty Triano. It's Marty at trianoburn.com. So give us your ideas. We already talked about the retreat coming up next week. There's a monthly e-newsletter that the real property section puts out. If you want to write something short, maybe there's a case that you saw, you want to write a couple of paragraphs or a page about it, that's a perfect place to get yourself in print, to get yourself published, to start making a name for yourself out there in the real property community. Or maybe you had an interesting experience with a case that you were involved in, you know, something that you can reveal without revealing any confidences of your client. Great to submit an article for the monthly newsletter. If you're a serious writer, you want to write a law review type article, right? Multi-page law review type article where what every sentence or every other sentence has a citation to it. It's a tough chore. I just did one last year. It's going to be published coming up soon. And I know I could not do it without the assistance of one of the colleagues that I work with at CAR. Thank goodness that he was there to handle a lot of that work for me. But that's another way, you know, to get yourself out there, to get yourself known, to get yourself published. And Michael mentioned, you know, there's opportunities, you know, at CLA generally and for real property specifically. We've got a DEI committee. We've got practice area committees. One of the new practice area committees that actually I'm interested in, I got to find out more about it, is we have an ADR committee. So a real property law section ADR committee. So if you're interested in any of those things, contact Franz Farrow. You see him there, FC Farrow at fdflegal.com. Wow,
Yeah,
I think
actually,
I'm
and then Neil, last month I did an ADR webinar with a retired judge, Suzanne Bruguera, and a private mediator. And that was last month. That was a lot of fun too. If anybody has an idea to do just a standalone webinar about any topic, you know, we can assist with that.
Yeah, any topic. Obviously, we like them to be somewhat real property related if we're going to be putting it on, but we're happy to do one ourselves, and we're happy to have you participate as well. So, yeah, we're open to suggestions. If you've got comments, ideas, suggestions, questions, interview ideas, we had such a great guest who was interviewed today, Jeff Huron. Thank you so much.
No, thank
And
you.
if any of our listeners have somebody that they want us to interview, you know, let myself know, let Michael know. We hope to see you next month, April 19th. We'll have 3 or 4 new cases to discuss, and we'll have a new guest that we're going to interview that will, you know, make you think about yourself, think about your law practice, think about your quality of life. And it sounds like Jeff really had a really great quality of life experience recently.
I did. Thank you again. And my pleasure. Have a great rest of your day, everyone. Thank you.
Thank you, Jeff, and thank you, Neil.